I tried. It sounds like it's on. Okay. Maybe I just need to pull it closer. Embrace the mic, right? So, welcome to the February edition of the Charter Review Commission's meeting. You want to call a roll?
For the February 16th meeting of the Charter Review Commission, we have Judge Adrian.
Here.
We have Davita Russell. Here. Victor Ruiz. Here. Claire Rizzaco. Here. Tom Persiak. Michael King.
Here.
Dennis Kennedy.
Here.
The Honorable Susan Drucker.
Here.
And Diane Downing. Here. You have a quorum.
Thank you. Folks, let me just kind of remind you, the last time that we were here, I think we got a lot of things done. We went through the list of potential issues that had been presented to us for us to review and to try to decide which ones we really wanted to take on. There were a total of about 10, as I recall, individual topics that we were looking at initially. We combined a number of them. We ended up with a set of priorities. One was the issue of the county's human resource department and the PRC, and some questions about overlap of function and reviewing how those two things could come together. The second was executive and council succession. The third was campaign finance language. And the last was Office of Inspector General, a review of its functionality and whether or not there needed to be some amendments made there. So today, or I think what we had, and you guys can correct me if I'm wrong, what I think that we had suggested that we wanted to do was to take a deeper dive on each one of those topics individually to give the individuals who were proponents and, of course, people who might be opponents an opportunity to give us more information about each of those topics so that we could be in a position to decide if there was a draft of language that would be beneficial to the county moving forward. To do that kind of on a monthly basis, because we're supposed to actually make a report in July, so we have a little bit of time to take it on. So this being February, the first order of priority was to look at the PNC and the HR departments and to hear from them in the interim period between the time that we were here last and today. It's my understanding that staff in both of those departments have put their heads together and have done a lot of the heavy lifting so that what had the potential of being somewhat contentious situation has now pretty much kind of resolved itself, and I love it when a good plan comes together. Okay. This is our first meeting where advocates are going to be able to make presentations about changes that they're proposing to the charter along with their rationale, and we'll determine which topic we'll present at the next meeting at the end of this one. We hope to take up one topic per meeting, and in the interim period, if there are things that we decide as a body that we need to do in order to make sure that we have all the information that's necessary to make good decisions, then we'll break into smaller groups to do that kind of review. And one of the things I hope to do by the conclusion of today's meeting is to determine what that process is going to look like. We have the benefit of having staff from the county law department in attendance to help us answer some questions today, and there'll be recommendations ultimately that have to be submitted to the county law department once we get through before we give it to the council. As indicated, we're through in July, And we want to have our final report to council no later than June the 30th. So timelines, again, are priorities discussed with public input, any expert testimony, and discussion, and any verbal recommendations that may be added onto what we do. That'll be this month, next month, in April. And thereafter, with the help of staff, we're going to move forward towards recommendations. And in the April and May meetings, we'll start that process to do those drafts. And if necessary, if we have to, if that's after we get into this, we determine that there's more that needs to be done, then we may have to add a meeting or two. I hope to not to get into the same level of meeting that the last commission had. But if necessary, as the man says, you know, a person's got to do what a person's got to do. Okay. And finally, we'll make our recommendations. And if there are minority reports on any of the issues that are raised, hopefully we'll have all of that done in time for our June meeting, where we'll do the final draft. It'll be necessary at that point for us to take a vote for submission to council and make sure that we are in position to transmit that final report so that it is in its final draft form before the end of June. And then it'll be our responsibility to make a presentation and to engage in discussion with county council if necessary by or before the July meeting. Okay. Any questions as the process? Okay. Hearing none, we'll move forward. Minutes from the December and January meetings are up for review. Is there a motion to accept?
So moved.
Okay.
Second.
Properly moved and seconded. Any unreadiness on the motion? Hearing none, all those in favor indicate by saying aye. Aye. Any opposed? Motion carries. We have currently representatives from both the County Department of Human Resources and the Personnel Review Commission to talk about a proposal and to meld their roles. Is there somebody present who wants to take the hot seat and take this on?
Good afternoon, everybody.
Good afternoon.
So I'll just speak for 1 minute. I think some of you know I was very concerned about this issue going into these Charter Review Commission meetings. There was vagueness and uncertainty and potentials for conflict in the charter deed between the PRC and the HR department. And I was expecting this to be a very contentious, difficult meeting. And I cannot take any credit for this, I have to say. I understand that the leadership of both the HR department and the PRC got together and worked together, and I think in the process built a good relationship as well. And it's my understanding that they have worked out a compromise, an agreement on language that does clarify the issues and does it in a way that makes both organizations happy and or at least satisfied. And so I will turn it over to them to explain it, but I have to say I appreciate their great work and their willingness to really sit down and try to deal with the issues that everybody saw, the vagueness and a lack of clarity, and everybody got together to work it out. So thank you.
Thank you, Mr. Budish. Well, as I often say, you know, nothing beats a failure like a try. So, you want to identify yourselves for the record, please?
Sure. Rebecca Kupczynski, the Director of the Personnel Review Commission.
Hi, I'm Ed Morales. I'm Director of Human Resources for Employee and Labor Relations.
Very good. Thank you.
So as the county executive said, the both teams from Human Resources and the Personnel Review Commission met and discussed at length the issues that had been problematic. And I'm very grateful to say that there was a extreme level of cooperation from both groups, and certainly the Department of Human Resources is very grateful to Rebecca and her team at the Personnel Review Commission for all the work that they did and helping to understand our point of view and in helping to meet the interests that we had expressed. And we tried to do the same. And so we are presenting to you jointly a proposal for charter reform that would meet the objectives that we've identified. So if we can move to the next slide. So the purpose of our review was to clarify the roles of the Personnel Review Commission and HR, to improve Article 9 by deleting what we perceive to be outdated language, to simplify ambiguous provisions currently existing in the charter, to ensure best practices and compliance, to promote fiscal accountability, and also to further the cooperation between the two agencies. And so the proposal that you have before you, I think, achieves each of these objectives. So first, with regard to the role of human resources, I'd just spend a moment. What we were trying to achieve was to make certain that the charter reflected the department's role with regard to management of the HR function for the county executive, and the fact that the department is led by a director who's actually our chief talent officer, Douglas Dykes, who reports to the county executive and is a part of the county executive's leadership team. We were also very concerned about the fiscal accountability issue. The county executive had pointed that out as a specific issue, a specific interest of his. And we wanted to make sure that the charter reflected the role of human resources with regard to a couple of functions that were not clear, recruiting and individual compensation decisions within the framework of the class plan and any ordinance or rules that council might adopt. So if we go to the next slide. But before we get there, both agencies identified the need to include a classification that is not adequately addressed in the existing language. So we proposed adding gender identity to the list of classifications that are included in the charter as important to protect from discrimination. So we proposed the addition of gender identity in that list. Next, we proposed the deletion of language that was placed into the charter regarding the appointment of the initial appointees to the Personnel Review Commission.
Since that ship has sailed.
Since that ship has sailed. That horse is very much out of the barn. Rebecca, are you going to take it from here?
Sure.
Okay.
So the next round of changes that we're proposing to Section 9.02, which really gets into the authority of the Personnel Review Commission. This is an area in general where we have had some, I think there's been some ambiguity that has led to some questions about what our role should be. The terms administration of compliance in particular and the authority to ensure certain things. So we worked very hard to come up with language that I think helps us to operationalize that. That's much more consistent with the roles that we've been playing, I think, in this whole thing. So I'll move through these one at a time. The first proposed change is to remove the term administration of, because clearly the Human Resources Department personnel are the people that are responsible for the day-to-day administration of those activities that comply with the relevant laws. And we want to replace that with reviewing and auditing compliance of federal, state, and local laws. And we're proposing to add local to keep that consistent with the code. That's currently language that's included in the county code. And then to add additionally the language at the end there of that sentence or that section that talks about this responsibility shall include the authority to submit reports and recommendations to both county council and the county executive. We think that that's the most prudent path for those recommendations to go to both of those entities so that there is both some oversight and some, awareness on the county executive's part as well. For the county executive's organization and departments, again, rather than authority to ensure, we're proposing the words review, audit, report, and make recommendations regarding that list of items that you see there. And we are proposing 3 changes in that list. The first is to delete the phrase training for total quality management, because it's not a management approach that's utilized by the county. It hasn't been since the new charter government was formed. The other thing is, as Ed mentioned earlier, the deletion of the phrase coordination of recruitment. That is an activity, a function that's performed by the county's Human Resources Department, and I think later on we propose to add that back into that section that talks about the Human Resources Department responsibilities. And then lastly, in the section, to delete the phrase compliance with ethics resolutions and ordinances passed by the council. This is a responsibility that has subsequently been assigned to the Inspector General. So we think it doesn't make sense to keep it in here. And then on the next page, in the next section, we have proposed to add an additional responsibility. This is to address one of those issues that we raised initially to you, and that was the clarity about the civil service function. And we've agreed to this language to add sole responsibility for civil service testing for both initial and promotional appointments within the classified service of the county. So that that proposed change would clearly address that issue. The next section, section 903, pertains to the classification system administration responsibilities of the PRC. The first recommended change is to delete the terms technical specialists, administrative, and clerical functions. These terms, we both have agreed, we're not sure where they came from, and they don't have much relevance to the way that we have currently organized the county's class plan. There are, we use job families that are much more specific than these broad terms that are being used, so we recommend deletion of those. And also, Ed brought to my attention right before we came up here that we would like to add one additional change here. At the end of that first sentence, well, midway through, the Personnel Review Commission shall administer a clear countywide classification and salary administration system for classified employees of the charter government to sort of delineate the parameters around that. And to confirm here, to clarify that those classification changes are in fact all adopted by council resolution. This language that we've proposed here also clarifies that there is a process now that would be in place when a proposed change to the county's classification system would have some sort of budgetary impact, that there would be a collaborative effort between the PRC and the HR department to analyze that impact and make that part of the recommendation that goes to council. And then the next proposed change down here is to add a statement that addresses another one of the initial concerns that we raised here, and that was to define the unclassified service. I think as we delved into this and we talked to Human Resources about this, we have come to an agreement that the language that's currently in the Ohio Revised Code that speaks to the exemptions from the classified service doesn't translate easily or cleanly to the county's organization, and we think that that warrants a good bit of study. And what we've proposed here is that council be given the authority under the charter to pass ordinances to address that issue, and so that's why we've added that language. And you want to talk about that? Oh, sure. Go ahead.
We have also proposed deletion of language in the charter here in 9.03 that is very difficult to understand and has been problematic right from the beginning in terms of its operation. I think that there, at the time that the charter was adopted, there was the notion that somehow the PRC may at some point have responsibility for other entities beyond the county executive and the other specific charter offices that are included in the document. That has not come to be, and we don't see how that could be in the future outside of significant changes to state law. So our thought process here is that the charter should simply and clearly state that the PRC has responsibility for employees of the charter government, as opposed to the list, the very cumbersome language that's currently included.
Okay.
In section 9.04, we aren't proposing any changes to that. Makes it easy. And then I'll let Ed go into the detail here. We have proposed some clarification to the role of the Human Resources Department in section 9.05.
So one of the real sticking points for the Department of Human Resources was the way the current language is drafted, without making in a way that does not make it clear that the Department of Human Resources is an executive agency that reports to the county executive. The language, almost reads as if the Department of Human Resources is sort of an ancillary branch of the Personnel Review Commission, which is not the case. So we've simplified the language, deleting the existing language and inserting instead that there is a Department of Human Resources that reports to the county executive and is responsible for management of all personnel matters for employees of the county executive. There was, in the existing language, there was ambiguity as to even what employees around the county the Department of Human Resources was responsible for. For example, the prosecutor has its own Department of Human Resources, so this language doesn't make that clear. And arguably, with regard to the existing language, there could have been a contention that the Department of Human Resources should serve that function for the prosecutor as well as the public defender as well as the county planning commission. And that just is not the case. It's an agency that is a part of the county executive's senior management team. I should say the Director of Human Resources on the next page is the individual who's part of the county executive senior management team, and that is what we've clarified here as well. In addition to including the recruitment function and the language regarding individual compensation decisions within the framework of the classification and salary administration system and or rules established by ordinance. So that is all we have.
Okay.
Thank you.
I read it all over. I think everybody got a copy of the PowerPoint, right? Does anybody have any questions about? Yes.
On the first one, the proposed change to section 9.01, if you're going to raise the issue of bringing in gender identity, and this is more of a legal question, what about people that choose not to identify? Does that need to be specified, or would that fall under gender identity?
I actually think it does fall under the concept of gender identity. So whether or not,
and I don't know. That's why I mean, it just because if we're going to introduce it,
sure,
you're going to either want to make sure you cover both.
Yes, and I'm pretty.
It's legally, I don't know where we fall.
I think that the purpose, obviously, is to make sure that no one is discriminated against because of the way that they identify themselves.
Right.
So if they choose not to identify themselves, once again, they shouldn't be discriminated against because of the fact that they choose not to discriminate. So I don't see it as a problem legally.
You think it falls under there?
I think it falls under there.
Okay.
Mr. Chair, I actually have a related question. I know
Yes.
Our new HR handbook that I know Council recently introduced to Council includes both the concept of gender identity and expression. And I was wondering whether or not that was contemplated in your discussions and whether or not you'd have an opinion as to whether or not that should be included here.
It actually wasn't, but that's certainly a change that would be worthwhile. I mean, it would make sense to have the two documents match.
Just by clarification for the record, you want to explain the concept of gender expression?
Sure. The best of my understanding is that gender identity has to do with how one identifies themselves. Expression is how they express it to the world.
How they're
So,
seen.
yeah, how they're seen. So it's, you know, particularly in sort of the trans community, that's an important distinction. So.
Okay.
I have
Yes.
there were three recommendations submitted. One from the HR department, one from the Personnel Review Commission, and then there was a third one from a program officer that wanted us to consider the role of the hearing officers. Did you review that and consider that in your plan? And if not, how do we discuss that amongst us?
Yeah, I'm not aware of that proposal, so, myself.
We are aware of it. I will tell you that the way the charter currently reads, it does give the authority to the commission to appoint hearing officers, and I think that the commissioner's position on this issue is that they believe that this is a staffing decision that they have the authority to make, and would like the Charter Review Commission, I think, to respect their authority to staff that function the way they think it should be staffed.
Okay.
So the proposal was to have the hearing officer not be an employee, if I understand it correctly.
As I understand it correctly, and this is Mr. McNays, and he's right behind me, but that's my understanding as well, and I can give you some history about this. When we first began operating, 2011, we had 50 or so appeals that had been filed when I started, and we brought 5 hearing officers on board that were contracted individuals, and we had about 300 appeals that were processed by those people. Our appeals have dropped off significantly, and we probably have about 20 or so, I think, actively filed right now. The commissioners, I think, felt that we made a recommendation to them to change the staffing model from those contracted employees to a part-time employee, because we recognized that as the number of appeals dropped off, we were going to have a harder time engaging contractors to come in and hear those hearings when there's so few of them to be done. And we shifted to a part-time hearing officer. So he works about 1 day a week, processes appeals as expeditiously as he can under those terms, and it's working pretty well. They are, to clarify another issue I think that he has raised in his proposal, those hearing officers are hired by the commission, and keep in mind that the commission is appointed by county council. That is a change from the first charter that was enacted. So I think that there is definitely an independence there, if that maybe wasn't envisioned in the beginning, but there certainly is now, and it operates that way.
Okay. Any other questions? Yes.
Just a couple sort of related questions, and part of this is just, I think, point of clarification in terms of how we're defining classified employees of the charter government. I know you mentioned excluding particular, separately elected offices. Maybe just for the benefit of this commission, if you could maybe clarify what offices are included in the charter government and which are excluded. And then related to that, when you talk about the responsibility of HR for management of personnel matters for employees of the county executive, does that exclude charter entities that may be independent from the executive, like council or IG or the audit committee, PRC, things like that?
Those are good questions. Let's go with the first issue with regard to charter agencies. If you turn to section 9.02 regarding the adjudication function of the Personnel Review Commission, there are a list of agencies that are included, and the answer in large part lies in that list, but I would also add a few more. So it's the employees of the county executive, the prosecuting attorney, the county planning commission, and the county public defender. But I would also say it would include any other office that is part of the charter, including the internal auditor, the council itself, and any other officer or department included in the charter.
Okay, so that's a non-exclusive list there.
Yes, and so with regard to, but that's from the beginning, that's been an issue, right? Which agencies are really part of the charter government. And we rely on an opinion that was issued by the Attorney General in 1992 at the time that Summit County formed, or rather subsequent to Summit County's adoption of a charter government. I think that happened in the late 70s, but the matter was discussed in an opinion in 1992 by the Attorney General, and there's an analysis regarding what agencies should be included and what agencies shouldn't be considered part of the charter government. So with regard to the Department of Human Resources, yes, it would be for county executive employees, but we would continue to offer ourselves to other entities to provide services as we have in the past. So the charter authority for the county executive, but we would remain open to assisting the internal auditor, the public defender if he requested, counsel. I just received a new county phone, and I don't know how to use it very well. That's why I tried to turn this thing off before we started, and it required my password to power it down. Sorry.
Thank you.
Okay. All righty. Any further discussion on this proposal?
May I just add how much we appreciate the fact that you got together and you worked out the issues that were raised, because it's so important, and cannot express appreciation enough, really, for you doing that.
Thank you.
Yeah, so we didn't have to go behind closed doors and put on the gloves.
Thank you.
Already done that. So with regard to the proposal that you're bringing forward, much more draftsmanship going to be required, and are you, the two departments, up to bringing us something to take a look at?
Absolutely. I think there's just a little bit of tinkering that needs to be done, a little bit of change that, as Rebecca said, and we will provide you with a final draft, certainly before the next meeting, probably within a week.
That's the way. I like it. Okay. Are we down to 5? Am I correct? Okay. Dan, you have a presentation you want to make? Want to identify yourself for the record?
Sure. Dan McNay, I'm a program officer with Cuyahoga County. And my proposal is coming from experience from being through the PRC on 2 occasions. And what my proposal brings is not only fairness, but equity. Equity to those that need to utilize when you unfortunately have to utilize the PRC from an employee standpoint. And what Rebecca indicated, where she feels it's working, my last go-around with the PRC lasted 2 years. So that part-time position that is making $156,000, first and foremost, since Judge Adrian is recently retired, I think that would be a wonderful position for him at once a week. So,
I think I could make that work.
The equity that my proposal brings is just to give employees a fair shot. The primary role of the hearing officer is to determine credibility. And just because an employee brings something forward does not mean that he is not accurate. So I think it's a simple proposal. Just, it shouldn't be a county employee. It should be give an employee a fair shake, I think you could find 4 attorneys out there and spread that $160,000 around and not make them county employees, to give each county employee a fair shake. Not fair, but equitable for everyone. It's my presentation.
Okay. I'm trying to wrap my head around the necessity. You're indicating that
One hearing officer, if I'm a police, fireman, whatever, and I've got to go to arbitration, and I've got the same hearing officer each time, how's that fair? So that same hearing officer gets to hear director after director for each individual case. You know, it just doesn't bode well. So it's the same hearing officer time and time again who's got a relationship with these directors because he's heard them time and time again. And if the cases are down, as Rebecca indicates, I still don't see one attorney turning down whether you giving a case in court. I don't see any attorney turning down work, especially when the PRC is paying so generously. At the number 14 paid employee, according to the report that was put out 2 weeks ago.
Okay, I see some hands going up in the back. Rebecca, you want
I'd like to clarify that this employee is paid per hour at a rate of $75. He's an experienced attorney and a labor arbitrator. He gets $75 an hour. He works 7 or 8 hours a week, so it comes out to about $28,000 a year at 160.
Where did this number come from?
I'm not sure who gave them those figures, but I can tell you that that's what he earns every week. So whoever gave, he probably got an hourly rate, and my guess is they extrapolated that he was being paid for 2,080 hours, which is not true. In fact, this part-time employee makes about $50 an hour less than our contracted employees did, because when we brought him on board, he also is a contributor to OPRS. The county pays to OPRS on his behalf, and he earns sick leave. So we were able to negotiate that rate down from $125 an hour to $75 an hour. And I will tell you from our experience, there weren't a lot of attorneys that were willing to work at that rate that have the experience that we need.
I find that hard to believe that there's a shortage of attorneys in this town that are in the Justice Center every day that are begging for work from the judges that are going to say no to the PRC because that's too difficult of work. I'm just looking for equity for the employees. One hearing officer, whether he should not be contracted, no matter what he's being paid.
You say 20 hours, 28 hours a week?
He works about 8 hours a week.
8 hours a week?
8 hours a week.
No, we're down. Let me ask this before.
I don't know that the commentary is getting on the record.
Oh, I'm sorry.
Thank you. Okay, to clarify, this employee is paid $75 an hour. He works and is paid on an hourly rate. So we actually were able to save money when we moved to this staffing model, because we previously paid these contracted attorneys about $125 an hour was their last contract. So he doesn't make $160,000 a year.
I have a question. Salary aside, so what I hear is also, is this a neutral individual because they're represented? They're an employee of the county. So I guess my question is, how is this traditionally done in other jurisdictions? Is our model different? Is it in line with anyone else's? Has it ever been challenged in court or anything like that?
Do you want, go ahead.
I can't speak to anyone else's model. I can only speak to my experiences here. It does not work. It worked. It can work if it's equitable. When you have the same individual with, first and foremost, if Rebecca could answer why mine took 2 years to go through. 2 years.
I'm always happy to answer questions about how long appeals take, but I need the detailed records of when there were objections filed. Would you like to speak to that?
I mean, I can say
Okay.
what happened. Hi,
Hi, Sarah DiCaro. I'm the staff attorney for the PRC. Mr. McNay had filed his appeal, and at that point, we were transitioning to a hearing officer, to a employee that was employed by the PRC rather than our independent contractors. And as we said, it took us a very, very long time to find somebody that was willing to do this, because there isn't much, we can't promise many hours a week. So it took us a long time to get that hearing officer on board. Once we got him on board, he had a backlog of about 30 appeals that he needed to hear. So that was what happened in this scenario.
So that bodes to my point. There's 30 cases that Sarah is saying that this individual heard, that this one hearing officer heard the same directors over and over testifying, and so who is credible? The employee doesn't have a shot when it gets in there.
I will say that we currently have 5 active appeals.
Ed, you want to be here? Okay.
Hello, Ed Morales once again for the Department of Human Resources. I wasn't aware of this proposal, but I will say in response to your questions, I've been a labor attorney for many years. I've appeared before civil service commissions. I appeared before the State Employment Relations Board. And my understanding of the way this is what is very typical is that the hearing officers, it can be either way, but it is quite typical for a hearing officer to be an employee of the Civil Service Commission. And certainly the State Personnel Board of Review has employees who are full-time hearing officers who are also employees of the state of Ohio, who handle these types of appeals for other counties. So that's a pretty typical situation.
How does it work for the Sheriff's Department, Ed? With picking up a hearing officer, an arbitrator?
So Mr. McNay is discussing the selection of an arbitrator when an employee is covered by a collective bargaining agreement, and that selection is based on a negotiated agreement between the parties, language that's included in each of the collective bargaining agreements. But
Which states? How does it work?
Very typically, an arbitrator is selected from a panel that is sent to us from the Federal Mediation and Conciliation Service. We do have some collective bargaining agreements that have a fixed panel of individuals, including at the Sheriff's Department, who hear all of the cases. And so that would be very analogous to the situation here at the Personnel Review Commission. So arbitrators for unionized employees can either be agreed to by the parties, can be determined based on a panel obtained from the Federal Mediation and Conciliation Service, or can be a negotiated set of names, a fixed panel that's in the collective bargaining agreement.
Yes.
Listening very well to the discussion pertaining to a non-fairness issue. I am from labor, and it does work both ways. In most labor agreements, there is a panel where you choose from versus a fixed panel. That is not the norm. That does happen, but most labor agreements have either a fixed a panel where you choose an arbitrator from, or you choose a hearing officer from. I feel both ways on this subject, because I do understand his point, because I've worked in that area where I had to be in a hearing and have the same person listen to the case each time from a different employee, and that same person is there, and after a while that person builds up a
Tolerance.
yes, or a bias, or a rapport, and it becomes harder for an employee to actually be heard, because sometimes they get blindsided and get deaf. So I do feel for I understand the position that you all are in, far as having someone, but I do recognize and feel that I believe that you need to have more than one person.
You know, if I may respond, I agree with you. I don't think that this is a proposal that reasonable people couldn't disagree on. I think that you could recognize some legitimate interest in the proposal. I would question whether or not it's compelling interest. I think that with our collective bargaining agreements, we use panels because we don't have grievances going to arbitration every day. And so there is no need, except for a few cases in the county where we do have a set panel of individuals that are included in the agreement. There's no need to have an individual who is a permanent umpire, for example, although there are companies that do it that way. I do think that it is advantageous because unlike labor arbitration, where there are a group of very experienced and expert individuals who can act as a neutral and who are aware of labor law and precedents with regard to labor relations and the interpretation of labor agreements. Unlike that situation, the hearing officer at the Personnel Review Commission needs to be an expert in civil service law. And that not every individual who acts as and I would say most individuals who act as labor arbitrators don't fit that bill. So the person who decides these cases needs to both understand the county charter, the county code, and civil service law, because many of our rules are state of Ohio civil service law.
Yes.
And that's a very arcane and difficult specialty.
And I agree with you 100%, but I was not talking precise about just arbitration, because just in regular hearings in a regular school system, there either are two hearing officers which switch off. It's either the human resource director or the manager or the superintendent who has a designee. So they rotate so that no one person is hearing everything. So that's what I was just talking.
I see that.
You want to add something?
I can just explain the process quickly, unlike the labor arbitration. So we have a commission that is comprised of 3 commissioners that are appointed by county council.
Okay.
Those individuals are not county employees.
Okay.
They are commissioners. What happens is the hearing officer hears the case, he prepares a report and recommendation. That report and recommendation is then heard by our commission, and our commission makes the decision, and before it's finalized, they issue a final order. So it's not
a
this
step
hearing
missing.
officer. That's
I
correct.
understand now.
So
There was a step missing.
There's a board of individuals that are not county employees that review all of the evidence and decide whether to adopt or not adopt the report and recommendation.
So if the employee disagrees with the hearing officer,
He comes to the meeting.
he comes to the meeting where the presentation is made.
That is correct.
Okay.
And he doesn't have a prayer. It's a rubber stamp. It's over with the hearing officer.
I would disagree with that.
I have a question. So does the employee come represented? Do they have the choice to have representation there?
They do.
Okay.
They do. And their lawyer comes to the meetings, to the commission meetings. In addition to representing them at the hearing, the lawyer is given the opportunity to submit objections to the report and recommendation that are given to our commission, and then they can come and they can make an oral argument, either the employee or their lawyer make an oral argument before the commission.
Have you, I'm sorry, outside of this proposal, have you had any problems with any other employees stating the same problem?
Not that I'm aware of.
None? Thank you.
Just out of curiosity, do you have any sense or idea as to what the percentage of concurrence is with the reports presented?
I mean, if if you want me to guess, I would say probably somewhere they concur, probably 75% would be my guess.
Okay, yeah.
Mr. Chair,
Mike.
I think the independent commission is an important factor in all of this, and I think the last charter amendment that was approved in 2013 has helped sort of establish that independence and credibility amongst the PRC in terms of giving employees a fair shake, generally speaking. My question, I guess, would be sort of twofold. One is if it did come to light or something, there was a conflict of interest with your one hearing officer, if there was, founded allegations of bias in some way, what process or protocol would you have to rectify that? And secondly, is there anything that would prohibit you from going back to that older model under the current charter language if that was determined to be the right course of action?
So the second question, there's nothing in the charter that would prohibit us from doing that. We don't have enough cases to have people on contract. If you're a lawyer, despite what Mr. McNay has said, I doubt that you're willing to take on, an 8-hour, $75 an hour job once a year. It's unlikely. We only have 5 appeals currently pending, and I'm guessing, in my experience, when I was in the prosecutor's office and we represented the county before SPBR, I would say, had approximately 10 to 15 employee appeals at SPBR a year. So I think now that the county reorganization is done, that there will be probably that'll level out to about 10 to 15 appeals a year. Remind me of the first question.
If it came to light that there was sort of a persistent bias or some type of conflict of interest that came up, I mean, would you have the option of potentially going out and finding another neutral on an ad hoc basis at least to adjudicate something?
We would have that option. The option is also available for the commissioners to hear the case.
Okay.
They can just sit as the
So
hearing officer.
they could be the findings of fact.
Correct.
Okay.
How is that process done? Is that done by request of the employee or?
Well, it has never been done, but I think if somebody came to our commission and said that they think that our hearing officer is biased and there was a credible, reason for them to say, we will hear this as a board, I think that they would absolutely do that.
And so
Go
I'm
ahead.
sorry. Go ahead. No, go ahead.
Is there anything in place to say that if an employee felt like they would be?
It's the appeal process, which it's for attorneys to fight, to dispute the hearing officer's finding of fact conclusions, and that's period. Then get in front of that board, that commission which you speak of, that we have this fighting chance. We're talking, this is the ex-HR director, all attorneys for other organizations. There's nobody up there for the employee to give you a shot. What I'm proposing is an equitable solution, and when we just talk about numbers, 30, 50, 300, those are people's livelihoods that got terminated, that got reductions in pay, that whole reductions in ranks. So when we talk about they're just 5. Those 5s are 5 lives that their paychecks are affected. They're fired. I'm just asking for an equitable solution, which I think is pretty fair. If the PRC is going to contend that they can't find qualified attorneys, then they're in the wrong business of finding qualified employees.
Yes.
Does the appeal process have a timeline? Because
2 years.
time was an issue. Is 2 years from, could you explain, like from when someone files an appeal, everything has to be resolved in 2 years, or?
He's saying that his took 2 years. There's no policy about how long that it should take. We do have goals that we have put in place for our hearing officer, and that's 60 days? Yeah. And it's 60 days, and I think...
From the date of filing that he hears the case, he or she hears the case?
Correct. You have to also realize that when, and a lot of employees do get attorneys, when there are 2 attorneys, one for the county, one for the employee, they can't always get together to have that hearing in a timely manner. But we do ask that our hearing officer get his report in from the hearing to the time of his report that's 60 or 30? 30 days.
It gets
Correct.
awfully expensive after 2 years. And there's nobody holding this one hearing officer accountable. After 2 years, nobody's holding them accountable. So maybe just spread out the wealth a little bit. So if this number of 156,000 is wrong, so be it. But I don't care if it's 28,000 or 156,000. Spread the love and make it equitable for the employees of Cuyahoga County.
Yes.
Just a question, maybe from a legal standpoint. I mean, there obviously are two sides to the issue, but I'm not sure that this falls in the category of something that needs to be in the charter. I mean, this seems to be more of policy, operational ordinance, but, the charter, it sets the high-level operations, so I would defer to you or someone else. I'm just trying to keep our focus on what needs to go into the charter.
Does anybody else got anything else at this juncture? Mr. McNay, we'll talk about it further as
I
a body.
appreciate you hearing me.
Not a problem.
I really do.
And, but the last point that was raised is one of the criteria that we set up for deciding, what kind of recommendations we would make.
And I would only contend everything you've heard has been stuff pro-employer, pro-Cuyahoga County to clarify. And so this is the only proposal that's on behalf of the employees.
Understood. Now, what I'm trying to say to you is that you may have the best argument in the world, but it may not be an argument for inclusion in the county charter or amendment to the county charter. There may be a better place for it. So one of the things that we have to take a look at is, as I said, we have a set of criteria that we're using to gauge every proposal that's put forth, and one of the criteria is, whether or not it's appropriate to consider it for the charter or whether it's appropriate for some other part of a fundamental document of the county, and whether we should make a recommendation that it go there.
And if I'm too late, then perhaps if the employees could appoint someone to the commission then, to give employees a chance.
Understood. Okay.
Thanks for hearing me.
Thank you. Thank you. Any further discussion on today's issue? If not, we're down to public input.
As to public input, we have Councilman Miller.
Good afternoon.
Good afternoon, Judge Adrian and members of the Charter Review Commission. When it comes to matters of council and executive succession when there's a vacancy, my initial inclination was to not say anything and let's see what the commission came up with on its own. But you folks kind of insisted and said you'd like to hear something from me, so I gave it my best shot. And these are my views alone, and don't necessarily represent the views of anyone else on council or council staff. In my opinion, there are two major problems with the current language. First, executive succession language, which has the council president automatically succeed to the executive, creates disruption in the council in addition to the administration, and neglects that the roles of the council person and the executive are very different. I got a little problem here, sorry.
Things happen.
What? That might help. Okay. Executive succession language which has the council president automatically succeed to the executive, creates disruption in the council in addition to the administration, and neglects that the roles of the council person and the executive are very different. My scan indicates that no one else but Summit County does it this way, and that the Summit County language says that the council president's succession does not create a vacancy for council president or council person, making it clearly temporary. However, for Cuyahoga County, and that should read Cuyahoga County, not County Council on the sheet. For Cuyahoga County, it does create vacancies. Second, current executive and council succession language relies on appointments, creating the likelihood that over time a high percentage of officers will have started by appointment, frustrating the democratic process. My proposal has the following key provisions. Number one, for executive succession, the law director will perform the executive's duties immediately following a vacancy, and the county council will then appoint an interim executive within 14 days. Number two, for council succession, the council will appoint an interim successor within 14 days. 3, except during the last year of a term, vacancies will be filled by special elections. 4, to save time and money, special elections will be a single vote with no primary. 5, to create the strongest democratic process and prevent the special election from becoming essentially a retention election, the interim appointee is precluded from running in the special election. 6, council is given power through the legislative process to specify additional details of the succession process and to provide for the handling of temporary vacancies such as disabilities. Included with my remarks are details of the proposed amendment and summaries of succession language from other counties with executive council governments. I've done my best to be creative and think outside the box, and I'm grateful for the opportunity to present these ideas for your consideration.
Thank you very much. Appreciate it.
So in the next page, the next page two-sided, it gives the actual language. I'm sure it needs to be researched and tweaked, but it's pretty close. So I will try to respond to any questions if there are any.
I think we're just getting this today, right? I mean, this is
Okay.
the first I've seen it.
Okay, great.
So let us take a look. This is on the agenda for next month's meeting. So we'll take a look at it. We'll give it to staff and give you an opportunity to weigh in again.
Okay, great.
Thank
Okay, I wanted you to have the chance to see it and think about it.
I appreciate that. Yes, thank you.
Next, for public comments, we have Audrey Morris.
Good afternoon.
Good afternoon. Thank you very much. I'm Audrey Morris from the League of Women Voters, and I would like to express the League's support for the Personnel Commission, Review Commission proposal, but the League has specific parts of it that we would like to address. In addition, we also like to express the proposal, our support for the proposal for the Inspector General, as well as the campaign finance proposal. But right now, I'm going to have Linda Meyer, who's our League specialist, go into the specifics about what we would like to have addressed in the Personnel Commission review.
Yes, ma'am.
Hello, hello, Commission. I just would like to say on the subject first, since you're trying to zero in on personnel review today, that we do support in general all measures that would strengthen or clarify the work of our county's Civil Service Commission. And it is a Civil Service Commission by whatever name. It used to have a different name. Now it's Personnel Review. The name doesn't, it's a Civil Service Commission. So we are especially concerned that as many employees as possible would be covered by its rules, and especially by its ethics-related rules, because ethics is a special area in which we've done a lot of work locally. Now, we worry about one specific problem with the personnel system. It's not the biggest one, but it's the one that concerns us the most, possibly because we know a little bit more about it. We worry about the steady increase of unclassified employees. And we don't see a clear definition anyplace of what an unclassified employee actually is, what that constitutes, what it should constitute. And so we strongly, again, support any proposal which would emphasize the merit and standards approach to employment with the county, rather than connections and, dare I say it, patronage of the county's excellent workforce. We've got a well-deserved new reputation for skill and standards and qualifications, and it would be well to have that a little bit more engraved in stone in the charter. Is it appropriate to address one of the other matters before, or should we come on the special day that's assigned for that particular issue?
More useful if you could.
Pardon?
Come on. It would be more useful, excuse me, it would be more useful if you could come on the day that we have set aside for the other issues. Because if you put it in front of us now,
Okay.
my fear is that it'd get lost.
We'll be
in the
more
shuffle.
specific then.
Yes, ma'am. That would be good.
Thank you.
Thank you. Appreciate your input. That's it? Okay. We are scheduled to reconvene on March the 7th at 4 p.m. Is that acceptable with the members of the commission? In the interim period, we'll get all of the things that have come out during the course of this reduced to write it. We need to kind of probably take a vote at some point, but not necessarily now. So next month, we'll be looking at executive and council succession. That'll be the topic on the table. Any additions or suggested corrections to the topic for today should be recirculated to the members of the commission, and we'll have them available when the time comes for us to take a vote. Is there anything else for the good of the order today? Hearing none, date having been accepted, we stand adjourned. Thank you.